Good morning.
As suggested in the title of the event, the distinguished senior advocate will provide legal analysis on some of the recent events surrounding the Edo State election, and this will take the form of an interview. Please post your questions in the Q&A section of the Zoom or whichever platform you are watching from. So let me begin with separation of powers. Now, separation of powers refers to the division of government responsibilities into distinct branches to limit any one branch from exercising the core functions of the other. Is there anything that has happened in Edo State that could be interpreted as a breach of the doctrine of separation of powers? Do you think the executive is encroaching too much into the affairs of the legislature?
Well, like you mentioned, our constitution is a federal constitution, and it's a constitution that also is structured along the lines of separation of power, where you have three branches of government: the executive, legislature, and the judiciary, all performing as part of one government, performing different roles, in a synthetic manner, in ways that will further aspirations to democracy, the rule of law, and pursuit of happiness. Under this system, the three branches stay in their lanes. For instance, judicial functions are for judiciary. That is the institution that keeps constitutional limit, that also enforces rights, declares liabilities, and also protects, enforces fundamental rights, Bill of Rights. Now, the executive is the one branch that takes the straw in executing the laws that are enacted by the legislature. So to that extent, the separation actually plays out like this. A purely executive act is not reviewable by the judiciary. Once it is a purely executive act, it becomes a non-justiciable matter before courts. Purely legislative acts can also not be interfered with by the executive, because those are legislative acts. And purely judicial, of course, none of the other branches can be judges. But that is by way of a conceptual separation. You do not have a total separation in practice. It is not even in the interest of the state for you to have a total separation, for you to have circumstances where the three branches will act as islands on their own without coordination. So you then have a facilitating doctrine of checks and balances, whereby conceptually too, you find instances where to a lesser degree, the executive, they make quasi-judicial decisions. You also find instances where you have judicial personnel acting executively.
What did you say? Judicial decisions?
Quasi-judicial decisions in their daily operations. Quasi-judicial decisions. For instance, where the executive sets up a commission, some commission or some committee to investigate certain instances and all that, you can't. But the law, in such circumstances, expects whoever is commissioned to perform those functions to act judicially, to be fair, to take into consideration principles of fairness that ordinarily judges would take into consideration when they are performing their judicial functions. And there are instances where the law will not uphold those decisions taken in the executive circumstances where the rights of fair hearing have not been upheld. Where somebody has not acted, in such ways as to say that certain rights which should have been catered for, which have been protected, which courts will ordinarily protect, are not protected. Now, whether the governor is interfering in legislative duties, or did you also include judicial duties, because that would be very, very far removed. Legislative duties, you will have to point to certain particular instances, for one to be able to say, oh yes, that was a step too far across the top. I mean, to ask a question like that, out of the blues, will lead one to some journey that will be uncharted, and you don't want to go on such a journey that I have no chance. So is there any incident you want to talk about that which must be one I'm aware of for me to be able to say that will not be in court? Because as a senior lawyer, I'm taking so I won't be part of the situation whereby I have to start making comments on matters court. Therefore, take contemptuously. But like I said, I just stated skeletally that you cannot, to be able to see, the concept of separation of powers in a complete holistic perspective, you must associate it with the associate doctrine of checks and balances. It may well be that the instances you have in mind is one where the governor may be acting pursuant to the doctrine of checks and balances, where both institutions, the executive and legislature, will have to, act in sync, or rub functions. That may just be so. But like I said,
as you rightly stated, we can't really, these, if I were to give examples, it would go contrary to the sub judice rule. So we can't really give examples, but we appreciate your legal analysis of that question. So let me move on to the next question. At a point, the National Assembly threatened to take over the powers of the state House of Assembly, and that was seemingly the first of its kind in Nigeria's political history. Is there any justification for that interference by the National Assembly, in your opinion?
Well, we also have to look at the facts again. The National Assembly does not ordinarily have the right to take over the functions of the State Assembly, because applying the principle of separation to federalism, the National Assembly makes laws for the federation, while the state houses of assembly make laws for the states, for particular states, that is. And you find out that our constitution is so prolix in designing the architectural setting of our federalism that you have areas of federal competence where the National Assembly makes laws, even though they make law for the whole country. You also have areas of fused competence where the National Assembly as well as the State House of Assembly make laws, for the country, and relating to their geographical jurisdiction. The National Assembly, national jurisdiction; State House of Assembly, state jurisdictions, geographical jurisdiction. Now, in such circumstances where there's fused jurisdiction, the National Assembly holds sway over the State House of Assembly, in the sense that if there is a legislation by the National Assembly on such matters, under the concurrent list, for instance, and the House of Assembly of the state makes another law, if that law runs contrary to what the National Assembly has provided for, goes without saying that under the Constitution, that the law made by the House of Assembly will be null and void to the extent of this consistency. Now, again, but we have residual powers. Residual powers are for states. That's the nature of our federalism. And there are so many times the Supreme Court has pronounced, that matters that have not been specifically listed in the legislative lists are for states. I'll just casually mention one. I don't want to start pontificating on states as if I'm addressing court. The town planning case that Lagos State won over the federal government. The Supreme Court said, look, town planning is a matter that is not listed, specifically listed in these lists, and therefore one for the states. That was how Lagos State won the battle in planning laws over the federal government. That's why even in the states, when federal government has property projects, it is the states that will have to approve the planning. So I mean that is for that. But there are circumstances, for instance, where if you look at our present provisions, Section 305 of the Constitution is one that provides where states of emergency can be declared. When there's a state of emergency declared in a particular state, it operates in such a way that the administration architecture of that state is suspended. It is suspended. And in that case, the National Assembly will be the one that will take over the legislative functions for the time being. Until the state is suspended. And also, if you look at another provision in the Constitution where there's a state of war, concerning a particular section of the country, and it becomes impracticable for legislative duties to be carried on by the legislators, there could also be a temporary suspension, and in that case, the National Assembly will take over. But other than that, other than these very, very, very rare exceptions, it is not usual for the National Assembly to want to posture, as if because it is a National Assembly, it can make laws for the whole country and take over the functions of the State Assembly. That is not what a constitution conceives. It will not be allowable for that kind of conduct. It would be an attempt, which gives mutual jurisdictions, mutual sovereignties. The National Assembly is sovereign in its areas where it has competence. And in those areas where it does not have competence, it cannot drag that sovereignty over the State House of Assembly. The State House of Assembly is sovereign in residual matters, for instance. I just gave you an example of planning laws, how Lagos went. So to answer your question correctly, except maybe I want to also attach this question to the real event. I'll tell you that the law is I've just stated it. The National Assembly stays in its turf. The House of Assembly stays in their turf. Where there's competency, like in the concurrent lists, the National Assembly holds the upper hand over the states.
Okay, fantastic, sir. I think based on what we see on the news, there's no circumstance that warrants that interference by National Assembly, according to what you said. So that's been very insightful. If we move on to the next question, we've seen decisions being made by convening of members of the State Assembly. Is there a quorum required for these decisions made? And is there a quorums valid in a State House Assembly? So could you please share?
Quorums are necessary.
Okay,
yeah, like I was telling you, quorums. There's no gathering of bodies where I hardly think there's a gathering where you don't have quorums. Section 96 of the Constitution is the one that sets a quorum for a third third of the number of members as the operational quorum for meeting. That's section 6.
This is for resolution, for resolutions passed.
Yes. Well, come on. I mean, if you want to remove a speaker, for instance, it's a 2/3 majority. So there are different kinds of. You need you need different kinds of quorums for you to be able to operate the House of Assembly. But the general quorum is a third. General quorum is a third members of the House of Assembly. So if you have your House of Assembly, that's 24, you will have 8. You know, and then if you have 7, then if you have more than 8, you have it. You know, so that is what the law requires for quorums. But it has to be able to do business. I just cited section 6 of the Constitution.
Okay, sir. So based on that, we can sort of draw parallels with what's happened in the State Assembly and come to our own conclusions. Well, thank you very much for your time, sir. No, go on. Carry on, sir.
Well, Mr. Abu, sometimes, these questions, when they are general questions, it's like if you do relate them to events, they become, then you have the opportunity of getting contextual answers. You have the opportunity of getting contextual answers, for instance. So you have to, if you relate them to events, you probably be able to explain it. But like I said, the Constitution has provided a quorum, 8 for the House.
Okay, sir. Well, thank you very much for your time, sir. We will contact you with regards to the footage of this, and you can find it on YouTube and on all our Business Day platforms. Again, thank you very much for your time and insightful answers.
My pleasure.